Thank you, Chair, and greetings to the team from the Legal Practice Council. Greetings to honorable members and greetings to the team behind us. Chair, the LPC, it's an entity that should at all times be beyond reproach. As it stands now, there's a lot that is left to be desired by the public in as far as the Legal Practice Council is concerned. With that being said, Chair, I've got a few questions that I would like to ask. The first question is, has the Legal Service Ombudsman ever found that the LPC was negligent? Is this true or not? If so, what was this regarding? Chair, I'm not sure if I should wait for an answer now or I should carry on with
your 10 minutes. So you decide. I think an exchange works better for me, but it's your choice.
Yeah, I think an exchange. I would like an exchange on that front. Has the Legal Service Ombudsman ever found that the LPC was negligent?
Well, in the time that I've been there, Craig, you'll correct me, I don't remember the Judge Desai saying anything negative about us. I do remember there was a matter in the Eastern Cape shortly after we came in, which I don't know if yeah, but since November, I don't think we've had any negative interaction with the judge. I want to take care of it.
Thank you, Chair. I just want to clarify, Honourable Member, that the disciplinary process happens at the provincial councils and provincial offices. So when we sit here and you ask that kind of question, we will not necessarily have all the information that the ombuds would have communicated to the provincial councils in regard to any matter that they might have dealt with. I would like to be given time to just check with all the PCs whether there has been any finding of that nature that you refer to, because the communication is done with the PC because that's where the DC process lies.
Okay, thank you. I prefer that answer. I think, Chair, here there's a situation where more than 100 legal practitioners have been struck off the roll. The Road Accident Fund was vindicated by the Ombuds report, which lambasted the LPC for failure to hold crooked attorneys to account. Is this team aware of that?
So, well, I'm not sure if I understand the question, but when you are saying 100 attorneys struck off the roll, to me it indicates that the LPC did act in the sense that that's the substantial punishment, that ultimate punishment that we can mete out is to strike off the attorney from the practicing role.
And then when the Ombud says, when the Ombuds lambast the LPC for failure to hold crooked attorneys to account, what do you say on that front?
Honourable Member, we're not sure on which report that comment came from. And just on the issue of the RAF and the Ombuds, my understanding, Honourable Member, is that when we received the 102 list, we did not receive it as complaints. We just received a list which said, law firm A, this is the double payment. I then distributed that list to the provincial offices because that's where the DC process happens. The provincial offices then requested a full complaint with details of the overpayment so that they can then proceed to investigate the matter. During that time, the LPs which were on the list were alerted of the list and they paid back the money. Now, when it went to the Ombuds, which is recent, you will know that out of the 102 firms, only 20-something had their information submitted to the Ombuds. Now, that should also raise an eye why out of the 102, only 20-something were provided to the ombuds, because that is the information the RAF then submitted to the ombuds, of which the ombuds then submitted to us, and then we then investigated that number. We cannot just investigate based on someone just saying we did an overpayment. Give us the details, show us this is the overpayment, so that we can then be able to investigate. And my understanding was that we received 20-something in terms of documentation, which enables us to investigate.
Thank you. The next question. Has the LPC ever opposed in court a matter where the Road Accident Fund brought a case to strike off a lawyer or a law firm from court?
Yes, there is a matter that I'm aware of. I don't know if I should mention the matter right here. It's the matter of K. Malau. I'm trying to recall the basis for the opposition. And there's a more recent matter of Treo as well. If you look at the structure of the legislation, the LPC is primarily responsible for taking matters to court. Yes, the Act 43 does provide that any party can take a matter to court for the court to apply an appropriate sanction. We generally, we do not receive a lot of those applications. We would oppose if we think that the relief sought is not suitable, especially with regards to the powers of the curator. Because remember, once the practitioner is struck or suspended, the curator needs to take control of the trust account, and that comes with certain powers. And if those powers are not suitable, then it becomes problematic. On the latest matter of Treo, the RAF actually brought an application for striking, while the LPC is busy with its own proceedings for striking. It just doesn't make sense.
Okay, thank you, Chair. Chair, the next question. On the, first a preamble. This is now on the medical legal claims. Unscrupulous lawyers, often in collusion with healthcare practitioners, who have lodged multi-billion rand fraudulent medical claims against the health department, have been offered a chance to retract their claims or face scrutiny by the SIU. Now, from the standpoint of the LPC, why are they even being given a chance to retract? Why are they not just barred from practicing law in the country? Because these people are known to be, most of them are known to be submitting fraudulent claims. Some of them have done them numerous times before. Why would they not just be struck off the roll in as far as the LPC is concerned? I understand that there's other entities involved and there's other people who are giving them a chance to retract and so on and so forth. But from the LPC's perspective, what is your view on this? Thank you.
Chair, it's definitely not the stance of the LPC to give a chance. Again, as I said earlier on the matter, that any collusion that might happen between LPs and the Department of Health is not something that we have capacity to deal with or to investigate. And the onus is on the Department of Health, just like it did on the Nonguba matter. It brought the matter to our attention, we investigated, we suspended, and we struck off the roll. If these matters are brought to our attention, whether they've been given a chance to reverse their claims, the LPC will not will deal with it as an attorney who's done fraud, and it will be dealt with accordingly. There is no other way around it, Chairperson.
Okay, thank you. Next question. What role is the LPC playing in ensuring equitable distribution of briefs to state departments and SOEs? This is now to black practitioners, to women and attorneys in rural areas.
The LPC does not have the capacity to do that, but you will note the implementation of the Legal Sector Code, which was implemented on September 2024. So there is now currently in place, as appointed by the Minister of Justice, 14-member legal sector legal sector Charter Council, thank you, Charter Council, which is now working vigorously to implement the code, engaging with the state, the SOEs and municipalities. I know because I'm assisting them with setting up their infrastructure that they are busy trying to engage with those stakeholders so that they bring to their attention the requirements of the legal sector code. So this is something which is just starting, but it is, of course, hindered by the current litigation by Norton Rose against the legal sector code.
Okay, thank you. There are allegations and reports of mishandling of disciplinary cases and financial mismanagement against the LPC. Right now, I didn't find any information about anyone being formally charged in a legal sense regarding these issues. The LPC is facing scrutiny due to these allegations, which include concerns about spending and failure to act in the public interest. I would like to ask the team sitting in front of me now, what is your comment regarding these allegations, especially on the mishandling of disciplinary cases and financial mismanagement?
So can I offer you the opportunity, just ask all your questions because you're over, and then at least you can get your answers.
And then I'll ask one more, Chair, it's fine. In the light of the LPC's decision to drop disciplinary charges against certain advocates and lawyers, does the LPC concede that such decisions risk reinforcing the public perceptions that the LPC is selectively punitive and often harsher towards black legal practitioners, particularly those seen as outspoken or aligned to or with the transformative agenda causes? And how does the LPC respond to widespread concerns that its disciplinary processes are weaponized against transformative agents while others escape scrutiny? Thank you, Chair.
So on the allegation of the mismanagement of the disciplinary processes, I think we've already stated to this committee that we agree that there's shortcomings in the disciplinary structure or the processes that emanates from the legislation. That, coupled with the volume and the staff capacity, does cause issues, right? We know that there had been allegations in some of the provinces of staff being involved in colluding with practitioners to fix the outcome of disciplinary processes, and those matters were subjected to internal disciplinary. For example, in Gauteng itself, we conducted a forensic investigation. At that stage, we didn't find anything relating to the disciplinary processes, but we found in some of the other departments. And as things stand at the moment, if memory serves correctly, we've already dismissed 4 employees because of that misconduct and the collusion with attorneys. Look, I don't think we're saying that we are perfect. We are not perfect. There are shortcomings, but we are addressing those. I don't know if okay. Maybe on the, yeah.
On the allegation of weaponizing against certain practitioners who are viewed as outspoken, that perception would be based on a misconception of how the LPC works. First of all, as has been mentioned several times today, discipline is not a function which happens at LPC level. It happens at provincial level. And it in fact principally happens at official level. In other words, it's the legal officer who receives the complaint, assesses the complaint, decides whether there must be an investigation committee. There's then an investigation committee appointed. That committee then investigates, asks the practitioner for his or her version on the complaint, assesses that, decides whether that investigation committee then decides whether it must go to a disciplinary committee or not. Then the disciplinary committee is appointed, and then there's an opportunity to be heard, and it makes a recommendation. And it's only when there's a serious recommendation, like, for example, or an outcome of, for example, a strike-off, that eventually makes its way via a subcommittee of the Legal Practice Council, which is the Disciplinary Oversight Committee, that it eventually ends up with us at the National Legal Practice Council level. The point I'm making is we do not put our hands down into the operational side of disciplinary inquiry. So we don't say we think you should go for that person but not go for that person. By the time it gets to us, it's been through so many processes involving independent people who are appointed to chair those inquiries. If the practitioner believes that any member of an investigating committee or of a disciplinary committee is biased or has got some kind of interest, they can object to them. There's also a right of appeal, which goes to the ombud. So there is no mechanism or opportunity, nor any evidence, I would suggest to you, that the Legal Practice Council puts its hands into matters and says, you must gun for this one and you must leave that one alone. It's a misconception.
Thank you very much. Is there a question that was not answered?
Just a follow-up. 1 minute, Chair. On that note, I understand that maybe at the level at national, there's no situation where certain people are being plucked out from the crop to say, no, go after this one. But what about provincial level or at the level with which you speak to now? Is there no situation or no case where it seems as though certain people are being told, listen, go after that person, whether it's at a provincial level or even lower than that? Because from a public perspective, from where we stand, that's exactly what's happening. And to say that at national level it doesn't happen, Chair, I don't quite accept that, because there's many other instances that we could go to right now that speak to exactly that. So just on that one, please. Lower than you, is it possible? Is it happening? Yes or no? Thank you.
It would be impossible for anybody to say that at the level of official someone was got at or someone was not got at. Just as you heard that there have been cases of corruption that have been uncovered where officials have colluded with practitioners to look the other way and so on. We can't say that, but the accusation was, there's a perception that the LPC is a statutory body, not that some bent official is acting improperly. That's a different kind of accusation for which you would need evidence.
The LPC is not at national level only. The LPC is a body in its entirety.
Yes, I understand that it is, but the accusations made against the LPC, if the accusation is that the LPC has been weaponized to act against certain people, that is a different accusation to saying that there may be an official somewhere who was got at. Completely different. Just as one corrupt official doesn't make an entire entity, body, government.
One corrupt official does, however, represent the LPC.
Okay, sorry, colleagues. So I think the answer is, I can't say there is no official who engages in that kind of thing. I think that was the answer, and it suffices. I'm not sure we can litigate it any further.